before a single ruling is made. This case already feels like a pressure cooker ready to explode. We've got a mobile home park, frustrated neighbors, mysterious overnight guests, and a lease agreement that's about to be tested line by line. The landlord says unauthorized people have been staying in the unit for weeks. The tenants insist it's just a cousin helping out during a family crisis. But here's where it gets serious. This isn't just about visitors. The defendants were already on a conditional dismissal, meaning they were on thin ice. Any violation could bring back the eviction case immediately. And according to the park's management, that's exactly what happened. Surveillance cameras, text messages, neighbor complaints, and one big question: who is actually living in this home? Let's break down how this situation spirals into a full-blown eviction showdown.
Well, she told me what she saw. Your version is he's there all the time, but he doesn't really live here. The neighbors are complaining, and he won't tell me what his name is. So he's an unauthorized occupant. I don't even know who he is.
I thought I'd give you his
Cousin
ID.
Jeff, cousin Kurt, you don't know his name? It's entitled Sturgis Mobile Home Park versus William Wadsworth and Clarissa Jackson. File number is 241243LT. Casey Strong is here on behalf of the park. And this is a motion to set aside the conditional dismissal and reinstate the case. Very often, in fact, most of the time, once there's an affidavit of default submitted, the case is automatically reinstated, and then it proceeds to a termination of tenancy, or often a writ.
This is a crucial moment in the case. The judge explains what a conditional order of dismissal really means. The tenants weren't automatically safe. They were on probation. They could stay in the home only if they followed every term of the lease. No unauthorized occupants. No unapproved pets. No violations of community rules. And the biggest rule of all: anyone staying longer than 7 days had to be screened and approved by management. So when the park submits an affidavit saying someone was living there for weeks, that's not a minor issue. That's a direct violation. The landlord doesn't even need a brand new eviction case. The original one can be reinstated instantly. This is the legal equivalent of being on parole. One misstep, and the consequences hit fast.
Ms. Strong has alleged that there was a conditional order of dismissal entered, and that you violated number 2 of the agreement. The defendants have allowed unauthorized occupants to reside in the unit. I have personally observed unauthorized occupants at the home for extended periods of time. I have personally observed the vehicle of unauthorized occupants in the driveway of the defendant's unit overnight. I sent a text message regarding the unauthorized occupants to the defendant and confirmed that there was an unauthorized occupant at the property. Upon information and belief, the unauthorized occupants are still at the property, and the plaintiff contends that you are in violation of the terms of the conditional order of dismissal, in which case they would ask for a writ of eviction. The conditional order of dismissal was entered October 1st. The defendant shall be permitted to occupy the premises at Lot 31, pay all monies due. The defendant shall not permit any occupants to reside in the residence other than those listed on the lease and approved. Defendant shall not permit the presence of any pets on the property unless approved by the management attached to the lease. Defendants will maintain their property in compliance with the leasing agreement and all local ordinances and regulations. Defendants will comply with all other terms of the lease agreement. Defendants will be subject to the terms of this agreement, and it should be actionable for a period of default from the date of this order. Probation period for 1 year. So the affidavit that I read from Melissa Wing would indicate that unauthorized occupants are in the premises in violation of the conditional order of dismissal. Is that the substance of it, Ms. Strong?
Now
Yes.
we get into the evidence, and this is where things start to tighten. The property manager says she personally observed the same vehicle parked overnight, saw the same person coming and going daily, and even texted the tenant about it. The response: it's my cousin. That might sound harmless, but legally, it's not. The lease doesn't care if it's family. If someone is staying long-term without approval, it's a violation, period. What makes this stronger is that the manager didn't just rely on memory. She documented it. She texted. She tracked dates. She filed a sworn affidavit. So the question becomes, was this a temporary visit or an unauthorized move-in?
Yes, Your Honor. And if you look at the documents that were submitted by the tenants, they state that they were allowing individuals to stay with them in violation of that agreement.
Ms. Wing, do you have a name of these people?
All I know is when I texted one of them, I wasn't sure who was responding. I assume Bill was responding because on October 29th, I asked who had been there for the last couple weeks, and he replied it was his cousin staying because they were going through his mother's belongings. I assume there was a death or something. And I reminded them that we had just signed an order not many days before that they would comply with the order. And he responded, well, that it was his cousin staying there. And then on November 8th, I reached out again because the same vehicle was there. So it was a significant amount of time he was there.
No.
All right, Ms. Wing, would you please raise your right hand? You swear or affirm any testimony you're about to give in this manner will be true to the best of your knowledge and belief?
I do.
And do you swear that the information provided in your affidavit of default, which was already sworn to in front of a notary, is true to the best of your knowledge and belief?
Yes, sir.
And you also indicate that William Wadsworth told you that it had been his cousin staying there.
Correct.
All right, Ms. Wadsworth, Mr. Wadsworth, and Ms. Jackson, what's your position?
I emailed Elaine. I know it was last minute. And I emailed.
All right, well, just a minute. I'm going to put both of you under oath also. Will you both please raise your right hand? Do you both swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes.
I do.
All right, go ahead.
I emailed Elaine a copy of an answer to this. It was last minute, but with the holiday weekend, it's been very hard to contact anybody or get any help with anything.
Ms. Strong referred to it. I don't believe I have it, so go ahead and tell me about it.
It was, let me just grab it. No, the text message that it was a copy of the text message as well that she sent, which she asked whose vehicle was there. Not been staying there for a couple weeks. That's not the message. And I did screenshot that and send it in because she just asked whose vehicle it was. It says that they cannot reside here, and in the lease it says over 7 days, and that's definitely not the case. He's been here helping give us rides to work because our car broke down, and taking me to my kids' sports and stuff at the moment, just very recently. But he doesn't stay the night here. We can get documentation if needed of who he lives, where he lives, and all that. The week that he wasn't even here, 5 days, and it was just dealing with, his aunt and his mom, passing away, but that's not subject to our violating our lease. So,
Here's the tenant's side of the story, and emotionally, it makes sense. Their car broke down. They needed rides to work and to take care of their kids. A cousin stepped in to help during a family emergency involving deaths and legal matters. From a human perspective, that sounds reasonable. But courtrooms don't run on sympathy, they run on contracts. The lease doesn't say 7 days unless life gets hard. It says 7 days, period. The tenants argue he wasn't living there. The landlord argues he was. And this is where the case hinges. What counts as residing? Sleeping there nightly? Keeping a car there? Coming and going daily? Legally, that starts to look like residency.
and I tried to send in the screenshots. I'm not sure how to.
Well, the reason they wanted to terminate your tenancy in the first place is because of unauthorized tenants in the premises. And then we signed this conditional order of dismissal and are right back in the same boat. And so it seems like you were cavalier about it. But I'm looking for the original
The first one, she said it was comply with the lease related to health and safety, disruption of quiet enjoyment, and then failure to pay on time 3 months.
Your Honor, we brought the action under multiple portions of MCL 600.5775 because there were numerous behaviors that were fitting the violations.
Here it is. Fail to comply with a lease related to health and safety, disruption of quiet enjoyment of other residents, fail to pay rent on time. And some of the allegations were that it was your visitors that were causing the problems. You agree to this conditional order, and now they contend that you have violated it. Under Section 5 of the lease, guests, without the landlord's written consent, any guest's stay shall not exceed a total of 7 days of any 12-month period, commencing with the first day of the guest's appearance. Any person who is a guest and seeks to stay more than 7 days must be screened by the landlord.
And we haven't had any guests residing here for 7 days. Either time. That's like,
All right.
I mean, that's like saying we have different, I feel.
All right. The stuff you were talking about came to the court at 2:05,
Yeah.
and the clerk just handed it to me. There's no dates on this. Hello. Just check in to see who the blue SUV is that's been staying overnight. I thought we were on an agreement and you guys were going to follow it. Before I reach out to the attorney, I'm going to give you an opportunity to reach out to me and explain. It belongs to my cousin and his mom. My aunt just passed away. We're helping him look over her will and complete other legal matters. He says today he'll have my aunt's belongings, moves out of her house, and everything else taken care of. Can the hot water heater be turned back on now?
This is a turning point. The judge reads the actual text message exchange, and it doesn't say just visiting. It suggests the cousin was there while handling estate matters, staying overnight, and needing utilities turned back on. That doesn't sound temporary anymore. And notice how the judge focuses on dates. The conditional order was signed on October 1st. By October 16th, the cousin was already there, and according to the manager, he stayed through early November. That's well beyond 7 days. Courts don't just look at excuses. They look at timelines. And the timeline here is not helping the tenants.
There was nothing about it being several weeks or date or whatever. I'm sorry, I didn't remember exactly what she said, but that's what the case that we received anyways. So she asked and we did promptly respond. I mean,
nobody here for a couple weeks.
He was still on
All
there.
right, her affidavit says, I have personally observed unauthorized occupants at the home for extended periods of time. I need to parse that out. I have personally observed the vehicle of unauthorized occupants in the driveway of the defendant's units overnight. I sent a text message regarding the unauthorized occupants to the defendant, confirmed they were unauthorized occupants at the property. Upon information belief, the unauthorized occupants are still present at the property. That was dated November 13th.
but he's been here. He has to give me a ride. We work opposite directions. So, and right now we're carless, just temporarily. So if his car's here, he's allowed to give us
Well, just a minute. I didn't ask you a question. And
Okay.
so you're just volunteering information, trying to get all this.
Now it's oath versus oath. The property manager testifies under penalty of perjury that she saw the cousin staying for extended periods, verified it with cameras, and even gave the tenants extra time to fix the issue. That matters, because lying under oath isn't just unethical, it's illegal. The tenants, on the other hand, can't clearly state how long he stayed. They also struggle to even say his name consistently. And in court, Uncertainty equals weakness. When one side has documented observations and the other has vague explanations, the judge is more likely to believe the evidence.
So, Ms. Wing, you swore under oath the conditional order of dismissal was entered October 1st. You filed your affidavit on November 13th. When you said the person was there for an extended period of time, that's from when to when?
Well, I was on vacation, came back on the 26th. He was there the length of my vacation, and I was gone.
All right, the 26th of what?
October. I was gone from the 16th and back on the 26th. He was there that length of time as I was checking the cameras, and complaints from the neighbors as well. And then on the 29th, I had watched them over the weekend and went up at night, did some drive-throughs. The vehicle was there overnight. He was seen coming out in the mornings, going in the evenings, and throughout the day. And then I reached out to them on the 29th and they responded. And then again on November 8th, before I even sent it over to the attorney, I gave him another week to cure the problem, and he was still there. And last night his car was there when I drove through at 10:30 p.m.
Yeah, and he was taking Phil to work because he works third in Three Rivers.
Then continues.
All right, her testimony was that there's video evidence of showing when he comes in and when he goes out. His car's there all night, and he was there. We just did this on October 1st. By October 16th, he was already there for at least 10 days. And if she's correct, all the way through the rest of October, all the way through November 9th. So it's her contention he's been there from at least October 16th to November 8th. And there's video evidence to support it. What's your position?
I
Hope so.
Yeah, there's video evidence of it.
I'm sorry, I couldn't understand either one of you.
I don't know if there's video evidence of it. I hope there is. I haven't.
Who is this person? What's this person's name?
My cousin Jeff. Kurt, sorry.
Kurt. His
Cousin Jeff?
Kurt.
Say that again.
My cousin Kurt. My cousin Kurt, sir.
Kurt. All right, I'm going to grant.
This is where it all collapses for the tenants. The judge makes it clear. They can't even name the person. The neighbors are complaining. The evidence supports long-term presence. And that's enough. The motion to reinstate the eviction is granted. The conditional dismissal is gone. The lease protections are over. At this point, the court isn't debating anymore. It's enforcing.
All right, I'm going to grant the motion. You won't even tell me what the guy's name is. Her testimony is that he's been there for and you won't even tell me his name. No wonder the neighbors are complaining.
Can hear you.
Go ahead.
No, he just gets nervous. I was trying to get him to speak up, but we can provide proof of whatever you need. I mean, of what the person, of time, of date, of whatever.
Well, they just did. She testified under oath that he was there from the 16th of October to the 26th, and he was still there after that. And you won't even tell me his name. So
he's here if he's here during the day, he's given us rides to work. If she's got evidence, please bring it forth. I think she should bear the burden to prove it.
She just did.
By proving with video, but she doesn't have it.
Well, she told me what she saw. Your version is he's there all the time, but he doesn't really live here. The neighbors are complaining, and he won't tell me what his name is. So he's an unauthorized occupant. I don't even know who he is.
I told you I'd give you his
Cousin
ID.
Jeff, cousin Kurt, you don't know his name. And so,
Okay. No, she wins. We should have one. We can probably do that. Yeah.
All right.
I don't understand.
Now you keep muttering. Is there something you want to say? You're both like mumbling under your breath, and I can't understand what you're telling me.
No, I was talking to him. Sorry.
Your Honor, if I might add, not only is the cousin frequenting the home, but in the previous eviction, it was noted that there was a couple of women who were homeless living in the woods right behind the park. We've since put a fence up around the community to try to make that a little safer for our tenants, but those same two women are frequenting almost daily. I don't know if they're coming to take showers or eat, but they just walk in the home when nobody's there. They just come and go as they want. I think they're pretty much doing anything but sleep in there.
No.
Do you know their names?
I don't, but they're also on the video.
I hope so.
Yeah, I need some of this video. I need to see this video.
Strong, what are you asking for an eviction date?
Your Honor, I believe this hearing was going to.
The judge could have ordered immediate eviction, but instead, he gives them 7 days. That's actually a small mercy in eviction court. 7 days to pack. 7 days to find housing. 7 days before the sheriff can remove them. This isn't just about rules, it's about real people facing displacement. But the court also has to protect the landlord's rights and the community's safety. Eviction cases often come down to this balance. Compassion versus compliance.
Hearing was going to be in person. So knowing that it was going to be by Zoom, we submitted an order of eviction and judgment to the court last week.
I have it. I received it November 26th.
Somehow
But are you asking for immediate possession?
Be willing to give them 7 days. I mean, it's kind of hard to pack up a house overnight, so I don't want to be that disgusting, but I would be willing to give 7 days.
All right. I reinstate the order for termination of this tenancy, and the writ of eviction will enter 7 days from today, which was November 9th or December 9th. Mr. Wadsworth and Miss Jackson, you got 7 days to move, or the sheriff can come put your stuff out. All right. I've got that order and I will sign it.
This case shows how quickly things can unravel when a conditional agreement is violated. William Wadsworth and Clarissa Jackson were given a second chance to stay in their home, but the presence of unauthorized occupants, documented by surveillance, texts, and sworn testimony, ultimately led to eviction. The judge didn't rule based on emotion. He ruled on evidence, timelines, and the terms of the lease. And when those terms were broken, the consequences followed. So what do you think? Should the court have shown more flexibility? Or did the tenants push their luck too far? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.